All right, welcome back, everyone, after that short but sweet coffee break. My name is Andrea Varga. I'm a lecturer here at Glasgow University, and it is my pleasure to chair this panel where we turn to knowledge and the ICJ, and we will be looking at some very interesting topics, including social media posts, satellite images, as well as the use of AI to parse ICJ pleadings and judgments. So without further ado, I will give the floor to Dr. Niccolò Ridi, who is Senior Lecturer in Public International Law at King's College London, who will talk to us about AI.
Okay, so thank you very much. First of all, I would like to begin by thanking James, Christian, Marina, and all of those involved in the organization of this conference, and it is a true pleasure to be here. So today I'm going to talk, and by the way, I have noticed something which for somebody who is going to talk about technology is ironic. I have lost the clicker. There we go. Okay. I'm going to talk about datification of the ICJ's output. So some of you know that much of my work has been about using computational methods to draw insights from large textual corpora, or according to my detractors, counting things and drawing pretty graphs. This is the perspective I'm taking today. So the fundamental premise I would like to start from is that at the ICJ, like most courts really, speaks to us through text. And when things are done through text, interesting things happen. So once it is out of the control of those who write it for the first time, the text takes a life of its own. This has been a hallmark of the history of law reporting. Peter Tjeerdsma, the great comparativist, used to say that the American legal system had evolved from a system of case law to a system of opinion law. It is not what decided that counts, but what has been written. Robert Jennings similarly used to talk about the tendency of international lawyers to cite passages from previous judgments as if they were the Holy Writ. And since I have a forthcoming book on this very topic, I could continue, but I will not. What I would like to get to is a bit different. So no text ever hindered misquotations or misuse, but what happens now that international law can be accessed, leveraged, used, or actually in software development terms, served by entirely different means. And this is what I mean when I say that the datification of the jurisprudence of the ICJ is inevitable. So what is happening at the moment is that we have commercial actors, we have software tools, which essentially are now maturing and allow essentially for the parsing, annotation, and conversion of the court's decisions into structured data meant for quick use. This is a process which is always underway in commercial databases and proprietary tools. And in other words, the question is no longer whether the datification will happen because it is here. The question is rather what the implications are and who will control it and how it will be done. So the point I want to make is that there is a danger, which is that the control that Jennings and Tjeerdsma assumed over, of which passages may become authoritative and so on, may now be ceded to not so much algorithms, but really infrastructures and actors whose processes are rather untransparent and opaque. So this promise having been made, let me proceed in 4 points. The first I would like to tackle is the opacity problem. The second is what datification demands of legal theory. And third, the political economy of legal data. And finally, quite a few sketches about a framework for public governance. So the first point I want to tackle is opacity. So I had started this with black boxes and reason giving. I'm not going to go there. But what I will say is that, what do I mean about the problem of opacity? Essentially, legal reasoning at its core is a public practice of justification. So courts give reasons, counsel give reasons, we argue about reasons, they externalize reasons. As Damashka teaches us, the judgment is not merely a record of cognition, it is an authoritative communication, which is institutional form. It is a performance that the legal community has learned to read. Now, commercial providers are racing to ship things such as AI for law, which somebody with a bit of a background in computer science I find a bit funny, but I digress. So the idea is that the system promised distilled rules, synthesized lines of authority, predictive analytics, and they are embedded in chat interfaces that answer legal questions in polished prose. Now, the trouble is not so much the interface, and I'm going to try to see whether this actually works. The problem is the fact that they do deliver whatever they deliver without a transparent account. And of course, they look like legal reasoning, but rarely they show their working, except of course the one that I developed that obviously works flawlessly, and it has been called in the only possible way, which is shapt.ai in honor of the great Shabtai Rosen, which I designed to do that. But of course, this is not a sales pitch, so I'm going to stop there. So the point I want to make is that a system that offers answers without an intelligible derivation of how it got there is of course something that sits very uneasily with the culture that we are, with the culture that we believe the ICJ has been developed for. So it invites over reliance on unaudited proprietary articles. It shifts interpretive authority to private actors whose methods, again, not transparent, we cannot really scrutinize. Moreover, and this is not a tech problem, but it is a capitalist problem, things are always best done on the chip, and this means that the classification of legal materials occurs using automated tools. And this actually leads me to a point which Andrea has wonderfully raised in communications with me, which was, since AI models do not think, can they capture reasoning? If law evaluates performance against transparent criteria, which it may or may not do, it is at least coherent to ask whether or not computational systems can reproduce the markers of legal reasoning. Now, one of the interesting things is that they definitely can. So Damien Charlatan and I tested that by introducing 10 AI-generated memorials into the Jest of Moot Court, and guess what? We scored a 97. So yes, of course they can mimic that, but what about parsing the legal reasoning? What about identifying all of these? The point is that essentially when it comes to understanding reasoning, this kind of tools can provide opportunities and risks. So they are an opportunity because the identification can make the structure of the performance of justification and reasoning more visible, teachable, and analyzable. So very much like what Mike and Cecily said about pleadings, for example, being wonderful teaching instruments. It is also a risk because a convincing surface can mask very poor methods. So there is a question of having to insist on explainable pipelines, which is something that commercial actors are not particularly happy to do. Now, this is not only a technical task, because of course, converting ICJ decisions, like every decision, but of course I'm focusing on this at the moment, and really international law in general into something that is more structured, which is, really structured data, compels us to answer with some precision questions that international lawyers have debated and really eluded for decades. So what makes a statement in a judgment a rule rather than an observation? When does a context-specific reasoning crystallize into a general standard? How should we represent disagreement in a way that doesn't really erase the fact that disagreement was there for a reason? And of course, I'm not discounting the fact that shortcuts for this have existed for decades, Shepard citations and so on. But there are important things such as these, which cannot really be, I would say, knocked together very quickly. You have to decide what counts, write it down, and accept that others will examine and contest your criteria. So ideally, one would want these things to be computationally explicit. And this is something that I would like to give you an example about. Now, we were talking about earlier on arguments. Actually, Cecily and Mike were talking about arguments. And this is an example from one of my current projects, which of course I am developing with the computer science people at King's, representing arguments from ICJ pleadings in a structured way. So essentially what we do is, by using language models, we annotate who makes an argument, what scheme it follows, what components it has, and when possible, we try to use Douglas Walton's argumentation theory to reconstruct the argumentative moves and the argumentative structure of a particular argument. Now, at the scholarly level, why do we do this? Because we want to do it, because we can, and because, of course, once arguments are represented with this granularity, we can ask new questions about how argumentation schemes travel, which arguments are picked up by opposing counsel, which ones reappear in later pleadings, which ones are adopted by the bench, and by whom on the bench, which formal structures tend to persuade, and in what cases. And you can see how this can also be perceived as attractive. Perhaps it is attractive as a product. I personally object morally to the paywalling of international law, but maybe it can be done. But there are 2 points which ought to be made here. And the first point is that you might disagree with me about the results, but at least I'm telling you how I got there, what kind of argumentation and technical approaches I have used to do that. And second, because I'm speaking to an audience of lawyers and not computer scientists, I can write code to do that, but can you? So the question is, the datification is not really about models, but it is also about power. So Sarah London, who started out, ironically, also as a law librarian, puts it this way: essentially, companies routinely paywall critical information, including law and science, so people who aren't wealthy or affiliated with wealthy institutions can't get access. So essentially, control over datasets and tools by commercial actors increasingly means control over interpretive authority. And if privately owned systems decides which passages count as rules, which connections matter, they silently shape how international law is made. Now, obviously, international lawyers perhaps do the same, but I have to think, as somebody who wants to be a scholar, that we might be the lesser risk. So there are 3 risks that I think are important here. The first is inequality of access, because well-resourced actors might have better access. The second point is the idea of privatized interpretation, because a black box model will declare lines of authority, it would create de facto canons, which we really cannot unpack. And the third, of course, is the fragility of critique, because, of course, if outputs cannot be audited, they cannot really be contested in any meaningful manner. This is why governance of this kind of things actually matters a lot. And this is the art of a project that I'm also pursuing with colleagues at the informatics department at King's, where we are trying to build essentially infrastructures, corpora, annotation schemes, pipelines, through which international law can be analyzed in more transparent and replicable ways, and so it cannot be paywalled. And by the way, of course, we're also doing the first pass with language models, which of course imports all sorts of biases. But the point I want to make is that this underlines how hard this work is. No single scholar, no single court, no single registry can actually do all of that. And this has to be sustained collectively, which leads me to the final point I would like to make. There are obviously things that the ICJ, for example, can do better, and its registry can do better. Those of you who have fought against the website of the ICJ will know what I talk about. But beyond that, of course, there are additional questions. And one of the fundamental ones, in my view, is the question of collective stewardship of this data. Now, Sylvie Delacroix, who is a colleague at King's and a great scholar of data governance, thinks that the best way of doing these kind of things is essentially creating data trust. So putting aggregated data under the fiduciary care of trustees who must act for the benefit of contributors and beneficiaries. So courts, states, scholars, civil society, not shareholders, however. Now, transposed to international adjudication, this means that we could potentially create systems to curate, release, canonical structure corporal judgments, maintain annotation schemes of this sort, certify tools that meet the criteria that we want to be met, and of course fund public interest training of these tools in order to benefit the community. So, quick conclusion, Datification will happen. The real choice is how it will happen, how it is going to be governed. We can drift into a world where international law is essentially mapped privately updated, and privately explained, which of course is a legitimate thing to do in legal practice. The question is, of course, whether or not an international adjudicator, the registry, the UN, the UN in the first place, should push for that. If we do nothing, the mediation of international law is likely to be outsourced. And if we act, we can treat this transformation as a public good and as a chance to deepen our understanding of judicial reasoning and to democratize access to it. So on the ICJ's 80th anniversary, to me, this seems an appropriate tribute to think about not just how to celebrate the court's textual legacy, but also how to ensure that the methods by which we read it reflect the values that it was built to serve. Thank you very much.
Thank you so much, Niccolò. That was a fascinating topic, which I'm sure we'll hear more about in the Q&A. So in the meantime, though, without further ado, I'd like to introduce Dr. Marina Fortuna, who is an assistant professor in public international at the Rijksuniversiteit Groningen, and she will be talking to us about state officials' social media statements as evidence before the ICJ.
Thank you, Andrea. Good afternoon, everyone. Thank you to the organizers for organizing this very interesting and very timely event. I hope you can hear me. So I think it is an obvious statement that the last few years have been quite a busy time for the court, which hears cases from a variety of branches of international law. But a commonality that I have noticed is the use in recent case law and the reliance on social media statements of officials. This has been done in various ways and for various purposes. I must remark that by no means the reliance on this evidence is overwhelming. No, it is not. But I do think it is something interesting, something new, and something worthy to ponder on. So at the same time, I must say that I think this type of evidence is particularly, or can be particularly revealing, and this is what we've seen in South Africa versus Israel, a case to which I will return in a bit. So the purpose of this presentation is really to map some of the uses of social media statements and some of the questions that I see have arisen and will arise in the future. To note, I will not be relying on social media statements of various international organizations or organs, which has also been brought as evidence before the ICJ and other international courts. So turning now to the first use of social media statements of state officials, this has been done for the purposes of jurisdiction, particularly in Ukraine v. Russia, allegations of genocide case. And the purpose there was to prove by the Council for Ukraine the existence of a dispute and Russia's awareness of the dispute already after the time that Ukraine filed the application to the court. And there the reliance was made on a post made by President Medvedev on Telegram. So on a post in which he explicitly referred to the Genocide Convention to characterize the acts committed in the region of Donbass since 2014. So this was used to show that, unlike Russia is arguing, there actually is a dispute and it is about the Genocide Convention, and Russia was aware of it. I think in the case of this type of evidence, also what I noticed is the interesting responses of the opposing counsel. For example, Russia, to this statement, to this argument of the Council of Ukraine, said, and I quote, "If TV and social media are prioritized over special, established, and specific channels, if statements made outside special established channels are prioritized over specific positions made through special established channels, then the working of the international legal system would be called into question." End of quote. So aside from the dramatic repetitions, of course, it seems that the respondents disprove not only the use of social media statements as evidence, but also showcase the potential threat or alleged threat it poses to the workings of the international legal system. At the same time, Russia itself relied on multiple social media statements in relation to the interventions that have been used that have been made in the case. So that was quite interesting and quite revealing. And there, when doing so, Russia tried to state that when interpreting such type of evidence or declarations of intervention, including declarations of intervention that tie to social media statements, one must look at the true intention of the parties. And in this case, Russia was arguing that the true intention of the those who were aiming to intervene was to actually side with Ukraine rather than do what they're supposed to do as interventions. Now, turning to the second use of social media statements, they have also been used as admissions of fact. Of course, the fact that statements may be used as admissions is not novel. This has been argued before in Nicaragua, and the court has decided that statements of high-ranking officials are of a particularly probative value when they acknowledge facts unfavorable to the state, but it does matter how these statements were made public. So this is what we have from Nicaragua. And recently, in the aerial incident case, so Canada, Sweden, Ukraine, UK versus Iran, a case concerning the shooting down of flight PS 752, the applicant state relies in its memorial instituting the proceedings on Iran's Twitter statement, well, formerly Twitter statement, in which the president characterizes the shooting down of the flight as an, I quote, unforgivable mistake, end of quote. And the idea there is to show through the social media statement, among other types of evidence, that this is an admission of the fact that actually Iran was the one who shot down the plane. Of course, the most notorious case in South Africa versus Israel, and somewhat before also in Gambia versus Myanmar, social media statements have been used to prove intent to commit genocide. Of course, in South Africa versus Israel, still at the level, at the stage of provisional measures, plausibility of rights. But there we see multiple statements from various officials, from members of the Israeli parliament, from ministers, from the prime minister, showing that there is genocidal intent. To that, Israel, as the respondent in the case, says something along the lines of social media words are cheap. And these are all, so everyone who's trying to make an argument based on that essentially brings forward information that is not credible. So I found, again, the reactions of the respondents to such type of evidence quite interesting. Already the ICJ in this particular case has reacted to these arguments. In the majority opinion, we see a reference to the piece of evidence, a social media statement made on Twitter, I believe, by the Ministry of Energy and Infrastructure. And the ICJ majority mentions that given that there are statements of senior officials, and seniority here, the fact that it's from a higher ranking official matters. So it considered it for the purpose of its finding that the rights are plausible. But of course, two notable dissents have also been issued, a dissent for various orders as well. So a dissent of Judge ad hoc Varga and a dissent on behalf of Judge Sebutinde. And if we look there, we see sort of the areas in which I think the discussions surrounding this type of evidence will go. So on the one hand, there is a discussion of the proper interpretation of these statements, the fact that the statements should be taken in full and in their proper context, that if multiple statements have been made, the applicant should not cherry pick from these statements, but show a common ground among them. And this is, of course, context and the need to put statements in context is often something that is argued by the parties to the case, so that the other party has decontextualized the statements or other pieces of evidence. And interestingly enough, this also echoes what now is happening at the ICC in the Hecatomb case, where also social media statements, of course, of a different kind, have been brought. And the argument has been made by the defense that the true meaning of such statements, an unequivocal understanding of their meaning, can only be done if you bring the person in front of the court and ask them to testify. Now, turning to the second point or argument that has been made in one of the dissenting opinions, the fact that a statement made by a person which does not have authority over, in the case of South Africa versus Israel, the military, and this ties, of course, to genocidal policy, etc., should not be taken into account. And this idea about the relationship between the statement and the function is also, interestingly enough, something that we see in recent cases at a domestic level. Completely different cases, but still they echo similar lines of argument, similar issues that are posed by this type of evidence. Now, I think the question that I grappled with after my initial curiosity in this topic is, do these statements actually, are they so different compared to other statements? Do they warrant a separate type of analysis? On the one hand, I see them have an alluring potential as a persuasive device because of their closeness, of their proximity to the receivers of international, or the ultimate receiver of international law, of its accessibility as well. But do we want to arrive at a situation that any statement made by a state official, or as not any perhaps, but more statements that we'd expect would be treated as either decisive evidence in a case or even a unilateral declaration, because there is potential for that as well. But also, on the contrary, do we want states to escape any form of legal consequences for the things that they say in front of the whole world? So I think that this type of evidence, social media statements by state officials, present both challenges and opportunities and many questions, because on the one hand, they may complicate the evidentiary record, they can also enrich it. And I think that my expectation is that we'll still see, alongside other forms of social media evidence, courts and international courts grappling with it, grappling with their dual character, and I'm curious to see what happens next.
Thank you so much. All right, and for our final presentation on this panel, we have Dr. Anna Ventouratou, lecturer in international trade law at the University of Sheffield, who is joining us online to present their joint paper with Dr. Eirini Fasia, who's a lecturer at Wageningen University and Research. Anna, are you with us? Is the connection okay?
Yes, hi everyone, can you hear me?
Excellent, yes we can. The floor is yours. You have
Great,
15.
thank you so much. Sorry, can you hear me? Yes.
Yes.
Everything okay? Yeah, all right. Hi everyone, thank you very much for the opportunity to present. I'm really sorry that I'm not with you in person. I am indeed presenting this paper that is co-authored with my colleague Eirini, that is currently on maternity leave, so she could not join for the presentation, but I am presenting on behalf of both of us. So as the title suggests, this is about the use of satellite images as evidence specifically before the International Court of Justice. Obviously, by satellite images, we mean pictures of the Earth, or of course other planets as well, but I guess that in most disputes at the moment, pictures from the Earth would be more pertinent, collected by sensors that are on board satellites orbiting the space. And these, as we know, are operated by governments or private corporations, which means that they are available commercially for sale, as well as sometimes in open access outlets, for example, pictures that we find on Google Maps, like the one that I have from the University of Glasgow here at this slide. So satellite images are providing valuable insights into spatial and temporal context of specific activities or phenomena. And for that reason, they do have an importance for the purposes of investigations, including for international crimes. So I have selected here some examples just to show you the variety of things that could actually be shown through a satellite image. And I guess that you can actually understand the significance for the purposes of international disputes and internationally wrongful acts. So we see here in this slide on the left an example from a satellite image from China, which shows particular features or characteristics of infrastructure that are more consistent with a military camp rather than an education camp. On the left bottom side, we see satellite images showing environmental degradation as a result of the conflict in Ukraine. To the right, we see craters in areas and at times where specific zones have been designated as humanitarian zones for safe refuge. And of course, here we see several pictures that I guess most of us are familiar with from Gaza that are showing widespread destruction or dense crowds around aid trucks, or we can see military infrastructure or military equipment, or the gathering of armored vehicles towards specific areas, which suggests that a military operation is about to take place. So what did we do with these satellite images? The project is a bit broader, but the specific paper is about how we can use these images, which are now quite commonplace in the media, in international reports, as well as to a certain extent in adjudication. How can we use them as evidence before the International Court of Justice? This has already been done, but we are looking specifically into the modalities of using this evidence. And we had two specific questions. The first one is whether these pictures are admissible. I mean, they have been used in the past, so in principle, it looks like they are admissible, but are there any objections that could potentially be raised to the admissibility of this type of evidence before the court? And the second one is, what is their probative value? So are there any issues surrounding the assessment of such evidence? And are there any challenges and factors that might potentially affect the probative value that they could have in the context of an international dispute, specifically before the International Court of Justice? So starting with the issue of admissibility, as I said before, we have seen satellite images being used before the court, and I will provide in a bit an overview of the practice. So there is no rule that precludes satellite images as evidence before the court a priori. The ICJ statute and the rules simply refer to the admission of documents as evidentiary material. Documents has been interpreted in practice very broadly. So this includes videos, it includes charts, it includes pictures, and it includes satellite images as well. So there is no a priori rule, no rule that would exclude a priori this type of evidence before the court. However, of course, admissibility objections on the basis of other rules of international law can be raised. And the ICJ in that context has the inherent power to decide on the admissibility of such evidence. Of course, we know from previous jurisprudence, for example, by the predecessor of the court in the case of Mavromatis, that the court should choose the rule that is best suited for the purposes of proper administration of justice, equality of the parties, as well as the most consistent with other rules of international law. So it's not an unfettered power, but it does have broad discretion to decide on admissibility. So what we did with Eirini is we tried to think of possible rules of international law that may affect, under certain circumstances, the admissibility of satellite images, somehow anticipating possible objections and try to reflect on whether any of these admissibility objections could be successful in practice. And the first one that we thought of is the so-called doctrine of the fruits of the poisonous tree. So we thought, is it possible to object to the admissibility of satellite images on the basis that they were obtained illegally? Now, for this kind of admissibility objection to be successful, one would have to prove two things. First of all, that there is an exclusionary rule in international law that precludes the court from considering or would make it improper for the court to consider evidence that has been obtained illegally. And the second thing that we would need to prove would be that indeed, under certain rules of international law, the production or dissemination of satellite images might indeed be illegal. So on the first issue of whether the fruits of the poisonous tree doctrine finds some kind of reflection in international law, we did not find any practice in interstate adjudication, and specifically before the ICJ, that suggests the existence of such an exclusionary rule or such a principle, general principle of international law. The only case that we found dealing with something relevant to this issue is the case of Corfu Channel, where, of course, we know that the UK has argued that part of its operation in the territorial waters of Albania was for the purpose of collecting evidence. What we know from that case is that the court said there is no such thing as a right to discovery by intervention. So you cannot really breach international law in order to acquire evidence. However, later on, the court did consider some of the evidence that was collected through this otherwise illegal operation for the purposes of reaching a conclusion. Although this was not explicitly dealt with by the court, it does suggest that perhaps illegally obtained evidence can indeed be taken into consideration. On the other hand, we know from different contexts, which are not necessarily transposable directly to the ICJ, such as investment arbitration, that indeed illegally obtained evidence can be excluded. So we have a few cases, including Methanex and EDF, which suggest that illegally obtained evidence cannot be used by the tribunal in reaching its conclusion. In those cases, in investment arbitration, what has been used as a basis for those arguments were more broad considerations of good faith, as well as proper administration of justice. And in the context of the ICJ, perhaps we could even talk about the general rule of ex injuria jus non oritur, which means that a state cannot benefit from its own wrong. Still, however, there is no indication that this is indeed an exclusionary rule that exists in interstate adjudication. So this would be the first hurdle for this kind of admissibility objection. The second, of course, is to show that the satellite image itself is illegally obtained. And this is even more difficult, I think, because satellites operate in outer space, so above 100 kilometers above national jurisdiction, so national airspace, which means that the freedom of exploration and use of outer space would apply here. And there is no rule that precludes satellites from collecting images, even if they are from the jurisdiction of a foreign state. Of course, we do have domestic legislations that do prohibit or limit the collection of and distribution of satellite images by their own nationals or within their jurisdiction. And this would indeed be something quite interesting here. For example, the United States prohibits US satellite corporations from disseminating high-resolution images from Israel, broadly construed to include also contested territories around Israel, which means, for example, that Google on Google Maps would still not provide any high-resolution images from these particular areas, and any other US corporation would be prohibited from disseminating, from selling this information to interested parties. However, even if those pictures were disseminated in contradiction with domestic US law, this kind of domestic legality would not necessarily mean that those images would also be illegal under international law, and thus they would not be able to be presented as evidence. After all, a state that is using them would not have done any wrong itself, and therefore any kind of consideration of ex injuria jus non oritur or perhaps even good faith would not be directly applicable. So we see low chances of success for this kind of admissibility objection. The second one here that we considered was the possibility of satellite images containing state secrets or national security information, We thought that this is, again, a relatively weak admissibility objection because there are a lot of other solutions which do not preclude the court from considering the evidence, such as having in-camera proceedings or excluding those pictures from the publication of the judgment rather than from the proceedings in general. And the last one is the claim that satellite images inherently, because of their technical complexity, are more susceptible to manipulation or to fraud. There are, however, lots of methods of authentication that can be used in order to show the validity of these pictures. And we thought, again, that this is a relatively weak admissibility objection, since in the absence of any clear indication of fraud, the court would still consider this together with other evidence. And most of the time, satellite images would not be presented on their own, but they would rather be used to corroborate information from other sources, such as witnesses, reports, etc. So overall, we think that there aren't really any strong admissibility objections to be presented in order to exclude satellite images as evidence before the ICJ. So the second issue here is, how do we assess that evidence? Are there any particular challenges or any rules that inform the assessment and evaluation of this form of evidence, and what is their probative value? So again, here, the statute and the rules of the ICJ do not provide any clear criteria on how to process and evaluate evidence. The general rule is free assessment. So the court can make its own assessment of the weight, reliability, and value of evidence. But of course, the final ruling needs to show that the facts have been proven to the degree that meets the standard of proof at each stage of the proceeding. And of course, the final decision must be a reasoned one. So we went back into the practice of the ICJ to see how many times satellite images have been used as evidence and how has the ICJ treated them. The first thing that we did was kind of like mapping the timeline. So how many cases had satellite images as evidence throughout the years? And we see an increase, but it's not yet visible. I see here that you see in the chart 2024, the two files did not sync, so this is not updated. But I suspect that within the decade, we will see a clear increase of the use of satellite images, which is consistent also with advances in the relevant technology and the availability of satellite images now to parties. The second thing that we looked at is, what are they used for? So what is the object of proof? And here we see a variety of purposes, which generally mirrors at the beginning of the presentation, where I showed all the different things that satellite images can show. So here we can see geomorphological characteristics in the context of territorial disputes or disputes relating to the environment, environmental changes, destruction of property, mass burial sites, dead bodies, military infrastructure. So there are a lot of different things that can actually be pictured from above. But the most interesting thing for us was the fact that the court doesn't really seem to rely, at least explicitly, on these images in many cases, really. So explicit references even to those images that were submitted by the parties were only done in 6 judgments. In 2 of them, they relied at least partly to these images in order to rule on the case, which were both territorial disputes. And then in another 4, they explicitly said that even in combination with other evidence, the satellite images were not sufficient to prove the claim of the party that presented it. So the conclusion here for us is that there are certain challenges that we need to take into consideration when using satellite images as evidence. And we think that this is important in order to improve the practice and to make sure that parties that want to rely on this evidence, they do this in a convincing and in the strongest possible manner. So first of all, it looks like the court places a lot of emphasis, understandably, on the quality of satellite images. So it needs to be a high resolution image. The problem here is that these high resolution images are not produced incidentally. So those satellites that take incidental pictures, they would not be of high resolution. And of course, it costs some money. So it's not inexpensive. It is recoverable by the winning party, but as part of the litigation expenses, having this kind of high quality satellite images is not the easiest thing. The second issue is the issue of objectivity. So simply having this picture is not enough. Someone needs to explain what it is that we see in its context, in the geomorphological context, as well as like more specifically, especially when we have different kind of like weather phenomena, or if it is dark, or more broadly, you need someone to explain what it is we see. And here we have a methodology gap. There are stakeholders that are trying to bridge the gap. So, for example, UNOSAT, which is the UN agency for satellites, has started doing trainings for the use of satellite images as evidence. And a way that states, a method that states have used to overcome this challenge is that they've been using images that have already been collected and analyzed by international organizations, NGOs, academic institutions, the media, which increases the objectivity and perhaps shows that it is more perceived as an independent and unbiased expert opinion on this. And it kind of like also perhaps to a certain extent sidelines the challenges of accessibility that I discussed before. And lastly, of course, judges would need to know how to use them. So perhaps one of the reasons why they don't rely as much on satellite images is because they also don't feel comfortable enough to understand and process what they see and to use it in the context of a judicial decision. So these were the main conclusions. No strong admissibility objections in our mind. Some issues around probative value and specific challenges that we need to consider when using satellite images. And overall, perhaps the conclusion would be that it is always important to corroborate satellite images and to use them in combination with other methods, because especially in the context of international disputes, there are certain things that you can simply not see in that picture. You cannot see if there was intention, you cannot see causation. So it is always important not just to show the fact, but also corroborate it with other information in order to show that all the elements of an internationally wrongful act have been met. Thank you very much. Sorry if I abused my time, and looking forward to the discussion.
All right, thank you so much for 3 fascinating presentations. And we are now ready for questions. Just one minor note I'd like to add. Niccolò is unfortunately not feeling well, so we'll save his questions for now. But if you have any questions for our other 2 panelists, fire away.
Thanks. I have a quick question for Marina. You mentioned, I think it was in relation to the function of the person making posts, that aligned with some elements of domestic law or some decisions in domestic law. Is that part of the research in general, like a comparison with domestic law, and whether yes or no, what domestic law? Like, was it Dutch domestic law, or yeah, I was just interested if you could expand on that.
All right, let's collect a few questions. I think will be easiest. Any other questions? Christian.
Thank you, Christian Tams from Glasgow. So my question goes to satellite imaging, to Anna's presentation. I hope you can hear this well, Anna. So I appreciate the focus on admissibility rules or exclusionary rules, but it seems to me it's pretty clear that there are none such, and it would be foolish to just write out or write off such a potentially dramatic bit of evidence. I wanted to push you a bit on the probative value, which of course, I suppose depends. But if you take one specific example, which I think you hinted at towards the end, you cannot really prove intent, or you cannot prove causation. Of course, not as such, and it's not going to be conclusive. But if you're looking at the cases, some of the recent ones that you mentioned, I mean, take South Africa, Israel also, can you imagine the case without satellite imagery? And would you be prepared to say a bit more on the probative value of the massive amount of satellite documentation that's been produced by Weizmann and others in the sort of the cartography project or the forensic approach? Would you be prepared to say a bit more, perhaps from this angle, not so much of an exclusionary rule, but given the wealth of information, how can you ignore it? How can you avoid the conclusion that it's going to be massively relevant to the way the case is being argued? Thank you.
Thank you. And we had one more question over here.
Hi, this question goes to Marina. You specifically focused on the role of posts like online evidence for like factual circumstances. So can we prove intent, for example? But I was wondering, and this has this question has haunted me for a while, and how far this sort of evidence can also play a role in relation to the sources of international law, like if we look at custom or unilateral declarations, especially maybe also treaties, treaty interpretation of specific declarations, reservations, and so on and so forth. Maybe you've given that some thought. I don't know if it's part of a larger project, so I would be happy to hear about that.
All right. Any more questions in the first round? If not, then Anna, could you begin by answering?
Yes, hi. Thank you, Christian. Yes, you're absolutely right. The admissibility objections, as we have discussed before, these would not necessarily be particularly strong, but we thought that indeed it is something that we need to investigate further because it can't be used. So we want to make sure that these are admissible and that possible admissibility objections have been dealt with. And there are some arguments out there discussing this issue. Now, on probative value, I am not suggesting at all that we should not use or consider this type of evidence. In fact, indeed, I think, as you said, that they are quite powerful, and the recent use of these images as evidence in the case of South Africa versus Israel suggests just how powerful this could be. Indeed, they have included in the submissions a lot of different pictures that are showing widespread destruction of civilian infrastructure, of marketplaces, of cultural landmarks, of schools, of hospitals, and so on and so forth. But there are certain things that have been done very well in the litigation strategy in this particular case, as opposed to previous cases, and some things that can be further improved that we do need to take into consideration. And this is what we are trying to highlight here. What could be the possible challenges in using them and how we can do it in a better way. So in the case of South Africa versus Israel, the pictures that they have relied on are mostly pictures that are publicly available. They have been analyzed independently by NGOs or research organizations. You mentioned forensic architecture, which is, of course, very active in this particular area. They are also replicating pictures that have been used by major international media, such as the BBC, by even CNN, New York Times, as well as other research institutes, which adds a lot to the objectivity and independence of the interpretation and analysis. And they do provide those in combination with a lot of other things, specifically in that case, which we're talking about, the crime of genocide, which has also the mental element, which is very important. We see here that the facts, together with other evidence, will probably be what would lead to the conclusion that the crime of genocide has been committed. But at the same time, just the fact itself, the widespread destruction itself, the disproportionality perhaps of certain attacks that can be seen through the satellite image may also assist in showing the mental element as well. So I'm not saying that the two are always disconnected, but it depends on the case. So we see, for example, in the pulp mills case, the satellite images were showing the algal bloom that was alleged by Argentina. So there was proof that this existed, but the court said still the images cannot really prove causation. So did this actually result from the mill? So it would depend on the circumstances. And I think that corroborating with other evidence and using everything together as a litigation strategy is quite strong. I hope that this answers the question.
Thank you so much, Anna. Marina? Yep.
Sally, thank you for your question. So this was a case from the US Supreme Court. And I think, if I recall the name correctly, it's Lindke. I keep wanting to say LinkedIn, of course, Lindke versus Fried. It is really about something different, so it's not related to international law in any way. It is about lower ranking officials, so to speak, posting certain things on their personal page. And the question was whether or not it can be considered governmental action and in which cases. And then the statement was from the Supreme Court that when the person posting even on a personal page something about a subject that they have competence and power in, then it can be considered a governmental action. So that was the domestic case. Maybe the Netherlands has something. I should actually look into it. And turning to Sarah's question, yeah, a fascinating question, really, because I think it does have potential for unilateral declarations. I definitely see it. For customary international law, perhaps for opinion juris, and for treaty interpretation. That is, I think, the most creative one. I didn't think about it. It will probably also be something that would states would most oppose, so this latter instance, but I do think it has potential for all three. So aside from serving as evidence, as opinion juris for custom, maybe even as state practice, but yeah, I think more for opinion juris, and maybe for interpretation, for treaty interpretation. Yeah, so I see the potential, I think, in a nutshell.
Thank you so much. Any further questions from our audience?
Thank you for your presentation. My name is Funcho from Korea Institute of Ocean Science Technology, and I'd like to raise one question concerning the satellite image. It's very short question. So my question concerns the difference between maps and satellite imaging when it comes to the territorial dispute. So I'd rather ask, is there any like a distinguishable criteria between the maps as an evidence and the satellite as evidence? And if we can consider the satellite image as a new source of maps, then whether it is applicable to the corpus of jurisprudence with regard to the maps can be applied to the satellite image as well. So that is my question. Thank you.
Thank you. Any other questions? I think it would also be good to collect 2 or 3.
There's a question from Zoom. Okay, there's a question from a person on Zoom. So she's asking, Rebecca Shu, she's asking, is in the AO on the obligation with states with regard to climate change, the ICJ came under some criticism for the way in which it consulted with experts phantoms that were not fully transparent. So do the panelists have opinion on this?
All right, thank you. Any further questions either on Zoom or in the room? I did not mean that to run.
Yeah, Anna, I have a question about if you think there should be a difference, maybe not at all, when satellite imagery is brought forward as part of some OSINT research or reports like from Bellingcat or things like this, because recently I remember, I think it was in the Netherlands and Ukraine versus Russia in the CHR, it was a point raised by Russia. So I would be curious to see what you think about it.
I actually have a question to piggyback on that, which is to wonder about the role. Actually, that's for both panelists. To wonder about the role of private actors in the provision of evidence. That's very true. I think they can potentially play a very big role in providing satellite evidence, for sure. But also, I'm wondering, if you're trying to look back on like Twitter statements from, years ago, that you at the time may not have necessarily thought to be relevant. It's also archiving, and then there's also like the open archive, open web archive, whatever. But so there are nonprofits active in both areas, but there's also like a large corporate influence in both areas. I wonder how that can have an impact on the provision of evidence And also in the case of satellite imagery in particular, for states that do not have access to their own satellites and may not have powerful allies with access to satellites, that, is there a question of like equitable access to available evidence there that they could provide to the court? Anna? Sorry, I know I just dropped a big question on you and you're like,
No
Okay.
problem at all. I'm really sorry, but I couldn't hear Marina's question. So a difference between what and what? I'm sorry, I couldn't hear you very well. If you could repeat.
Yeah, no problem. So if these images are part of OSINT research, so for example, of reports issued by Bellingcat, do you think it would have any consequence in relation to the set of evidence or not? Do you hear me now?
Yes. Great. Yeah, thank you so much for these questions. These are all really great food for thought. So on the first issue of the difference between satellite images and maps, especially in the context of territorial disputes. So I think that the difference here would be on the reliability of these different means of evidence. So assuming that a satellite image is not manipulated, so it is a true satellite image from a certain point in time of a certain space, the geomorphological characteristics that it depicts would be as they are, right? So the objectivity of that picture cannot really be placed easily into question. So one could say, oh, what you see is not does not necessarily suggest X, which is a matter of interpreting the image, but they wouldn't really contest whether there is, for example, a body of water in that particular area, or where exactly a line of mountain starts and ends. With maps, there's always the human element. So you are mapping something based on how you see it and based on available evidence. And especially when it comes to historical maps, the accuracy and objectivity of these maps is not the same as it would be from a picture taken from above. And I do think that right now, satellite images are pretty much doing all the heavy lifting here in terms of mapping specific geomorphological features for the purposes of territorial disputes. So I hope that this answers the question on this. So now, Marina, I think that this is a really good question, and it does come up in case law. And I think that this is something that relates to the point about the perceived independence and the perceived possible bias and the perceived objectivity of the person that is doing the interpretation. This is why it is quite important to have an institutionalized procedure for interpreting satellite images. And we see this in different contexts. So in the context of the ICC, we have a specific team within the Office of the Prosecutor that does all the research, the purchasing, and the interpretation in-house of these particular images, which perhaps increases the consistency and the objectivity of that particular process. When it comes to states now, indeed, relying on secondary sources, again, depends on the perceived objectivity of the person that is doing the interpreting. So forensic architecture, for example, is an academic institution. It is independent. It has been accused by others of being non-independent and being biased. So it would be the perceived independence or the perceived non-independence of the person that is doing the interpreting that might actually affect the probative value of those images. Andrea, about the private sector, there was already a question in the chat on this actually about cooperation and complementarity with domestic governments and evidence collection by the private sector, which I think is what you alluded to with your question here as well. There are definitely issues there. So as I said before, the images that are available publicly and that they collect incidentally pictures from around the Earth, these are not high resolution enough to prove what we may need in the context of an international dispute. So having access to the pictures that we actually need is an issue. So, and as I said before, it's not inexpensive. It's good that we have precedent from the ICJ that this is a recoverable expense, a recoverable litigation expense. but it is a lot of money. So that's why we see the practice of using secondary material, things that are already publicly available, which again rely on grants that have been received by others or cooperation agreements between satellite companies and the media. Planet, for example, has a lot of cooperation agreements, and that's why we see a lot of Planet Labs pictures at the BBC, in Guardian, etc. So there's definitely an issue here of collaboration between courts and civil society and research institutions, as well as the private sector. And there is perhaps a spin-off with something that I have not researched yet, at least. Another question here, which is whether the court itself should be able to procure this kind of evidence, or even ask parties to produce this kind of evidence in the context of a dispute if they think that this is going to be an important factor to determine the case.
Sure. Yeah. Okay.
I don't want to derail the questioning period, but I just have a quick follow-up question. What do you mean by a recoverable expense in this context? That's it.
Oh, just that the winning party is actually able to add the cost of satellite images into the compensable expenses that they will get at the end of the dispute.
But so you're talking about recovering costs from the other party?
Yes, indeed. We have, as part of the litigation expenses, we saw in the case of Costa Rica, Nicaragua, that the court was actually able to include the cost of purchasing satellite images as part of the litigation strategy of the winning party. So you can add this to your expenses, but obviously you still need to pay for it as part of your litigation expenses while these are happening.
Although in Costa Rica and Nicaragua, the court didn't order costs, right? So, and the court has never ordered costs to my knowledge. So, I mean, it's definitely a theoretical possibility, but I don't think it's been done to date. So I'll leave it there.
Thank you, Cecily. Anna, any final comments on that? No, that's all right. Then we move back to Marina.
Regarding your question, Andrea, with the involvement of non-state actors, private, so to speak, parties, I think we've seen this already materialized in relation to social media evidence in the case of Gambia and Myanmar, and the fact that the the Facebook account of the military commander-in-chief of Myanmar forces was suspended for hate speech, and the domestic cases that this led against Facebook. And I think Michael there, not to throw him under the bus, is the person more competent to speak about it, because he authored two lovely, very interesting blog posts. So I think this is already happening. And there was a question about the phantom experts, I believe, and I think that is not something new. I think that happened before, for example, in the Pulp Mills case. So I don't think I have an opinion on that, I must admit, but I think that it's definitely not something that hasn't happened before.
All right, thank you very much. Any final questions to our panel? If not, then please join me in thanking them for their excellent presentations. All right, we'll have a short break and we will reconvene here back at 5 for the fireside chat with Patrick.
I'm sorry, can I just very quickly, just because I was just looking for my reference, just to say here that in the case of certain activities carried out by Nicaragua in the border area in the question of compensation, the court under the heads of expenses with reference to which it considers that Costa Rica has failed to meet its burden of proof, it did include the purchase of satellite images, and this is what I was referring to before as as having an acknowledgement that this is a compensable expense. Sorry for keeping people in, but I was just looking through my files.
Thank you so much. We all learned something. Thank you. All right, see you back here.